I wonder, do you remember what Judge Malarkey said to you at your sentencing?
I think he said he's only given me 48 years because of my age. Is that the part you're talking about, ma'am?
No. So right before he handed you your actual sentence, I'll read it to you. He said, I don't see any likelihood that the offender is going to conform his conduct to the requirements of society. I see none absent some incredible life change. It is depressing that he took such a young life and he is in effect forfeiting his own.
We are about to watch a commutation hearing for a man out of the state of Connecticut who was given a 48-year sentence in 2007. His whole argument for the reason that he got this commutation sentence was that his attorney never allowed or was open to him taking a self-defense plea. And there are arguments around why maybe it should have been. Before we watch this commutation hearing, we're going to take a time travel 2 years back in the past, where he goes through the process of applying to have this commutation hearing. Also want to say special thank you to Richard. This was important for Richard that I cover this. He highlighted this in the spreadsheet. He said, please cover this, Mandoo. And as of now, it's March 22nd. Haven't heard back from Richard about his surgery. So I am doing this with him in mind. Hope he's okay. When I do hear back from him, I'll let you all know.
And also warning when your time is up. So this is the matter of Charles versus Commissioner docket number 43643. We will begin and hear from the appellant.
Yes, Your Honor. Before I begin, may I reserve 5 minutes for a rebuttal?
Yes, you may.
I would also like to, before I begin, I may, and I mean no disrespect by this, but throughout my argument, as I did in the brief, I may refer to the decedent, Dennis Finial, and one of the witnesses, Jaquan Finial, by their first names, Dennis and Jaquan, just for ease of the court. But I certainly mean no disrespect by that.
Thank you for that clarification.
May it please the court. This is a case that from the onset cried out for self-defense. The basic foundational documents in this case should have led competent counsel to meaningfully consult with Mr. Charles about the viability and raising self-defense. As the discovery evidence in this case made very clear, at the time of the shooting, there were only two people standing together, Mr. Charles and Dennis. And they were engaged in a one-on-one, hand-to-hand confrontation. They were fighting. We know that Dennis had a gun. That was never in dispute. And as the two other eyewitnesses, Natasha Walker, an individual who had both a prior relationship with Dennis, but also a person who knew Mr. Charles. And so as Miss Walker and as Jaquan both told the police immediately after the shot was fired, Mr. Charles was seen running away with a gun in his hand. Now, this alone cried out for meaningful consultation with Mr. Charles about self-defense. Now, at the time of the shooting, Mr. Charles was young. He was 18 years old. He had been living in Hartford his whole life. He dropped out of high school in the 10th grade. And his statements to the police, although he admits at the habeas trial not entirely truthful, follow a clear progression. They progress towards the truth. And as I noted in the brief, when he first is arrested and speaking to the police, he denies all involvement. But after some time, he asks to speak with his mother. They tell him that people have told them that he had a gun. He gives a written statement. And in that written statement, Mr. Charles all but admits that he had a gun and that he shot Dennis. In that written statement, he describes an altercation over the cell phone. He describes having to grab Dennis's arm to prevent himself from being shot after Dennis pulled a revolver on him. He describes feeling cornered in, having to handle the situation the best he could. He says he was hurting because he didn't want to see Dennis dead. Dennis was a friend of his. But most importantly, he ends his statement by saying, "I couldn't believe it. This all happened so fast." But trial counsel, instead of consulting with Mr. Charles about these statements and the statements from the two others who put a gun in Mr. Charles's hand, and discussing the possibility, the viability of a self-defense claim in this case, trial counsel decided on his own, without consulting with Mr. Charles, that a third-party culpability defense was the best option in this case. And trial counsel decided this despite the fact that he would have to discredit both Jaquan and Natasha Walker, who both put a gun in Mr. Charles's hand, despite the fact that nobody, including Mr. Charles, put a gun in Jaquan's hand, and despite the fact that the third-party accidental shooting left so many questions. For instance,
Counsel?
yes, I'm sorry,
Judge
Judge
DiPentima.
DiPentima.
Yes. I just had a question.
Yes.
Can you
I
hear me?
apologize. Yes, I apologize. I don't see the hands though.
I went like that. Here's my hand.
Oh,
Okay, my
I apologize.
question is, wasn't there testimony that Jaquan had a gun in his hand?
no, Your Honor. At the trial, Jared Charles testified that he believed that it was likely that Jaquan had a gun. He testified that based off of his knowledge of Jaquan, his knowledge of Jaquan and both Dennis, that he believed it was likely that Jaquan did have a gun, but he specifically testified that he did not see Jaquan with a gun and that he never saw that firearm.
What, just shifting gears slightly, what was the testimony at the habeas trial about the trial counsel's knowledge of the fact that the self-defense claim was so, what you're saying was so strong?
Well, at the habeas trial counsel maintained that self-defense wasn't a defense in this case. In fact, I believe his exact testimony at the habeas trial was it didn't exist. Trial counsel's opinion, even at the habeas trial, was that a self-defense claim did not exist because Mr. Charles failed to admit essentially to the police in any of his statements, and I say his statements, in his one written statement or his two verbal statements, that he indeed had a gun and shot Dennis. And so trial
I'm sorry, counsel, but wasn't there testimony from the habeas counsel that he doesn't remember Mr. Charles even raising self-defense as a possibility? Am I wrong about that?
No, you were right, Your Honor. He testified, he said he didn't recall, he unfortunately didn't have any of his notes from the representation, and he didn't recall whether or not Mr. Charles had told him that he had a gun or acted in self-defense. But later in the habeas, oh, I'm sorry, Your Honor.
Well, I was just going to say, so the habeas court had your client's testimony about self-defense, and you're arguing that the evidence that trial counsel had before him, the discovery material he admitted knowing about, should have told him there was a self-defense here.
Yes, Your Honor. We certainly do maintain that Mr. Charles did tell his trial counsel that he had a gun, that he shot.
But the court didn't believe that. Habeas court didn't believe that, right?
The habeas court, it's not entirely clear. It does appear that the habeas court did not credit Mr. Charles's testimony. However, this court does not have to find, and that's part of our argument, this court does not have to find that Mr. Charles indeed told his trial counsel that he had a gun and that he shot Dennis in self-defense. because of course our argument is that the evidence beyond any statements that Mr. Charles may or may not have made to trial counsel put a trial counsel on notice and required meaningful consultation with Mr. Charles. We certainly know trial counsel testified at the habeas that he did not have a conversation. He recalled that the first time he had a conversation about self-defense with Mr. Charles was indeed when the trial judge instructed him to. I believe trial counsel stated that the judge made him. But this conversation was in the context of a self-defense jury instruction. And of course, by the time that this conversation occurred, Mr. Charles had already testified, the state's evidence had already been put on, the defense had already been put on. And so our position is, at that point, this conversation about self-defense was a little too late. And indeed, the evidence that trial counsel had in discovery cried out for meaningful consultation with Mr. Charles. Beyond Mr. Charles's statement, which I described earlier, which talks about feeling cornered in and wishing that it didn't happen, there were the voluntary statement of Jaquan. And Jaquan describes an argument over a cell phone between Mr. Charles and Dennis. He describes Dennis's raised fist right before a shot went off. Jaquan subsequently gave an oral interview with the police after he had received immunity. And indeed, at that point, he admits that that after the shot was fired, he ran up to his cousin Dennis and he took Dennis's gun, and then he chased after Mr. Charles and fired 5 rounds at Mr. Charles. And what we know from this important statement is that Dennis's gun was out. At the time of the shooting, Jaquan doesn't describe fishing through Dennis's clothes for the gun. He says he ran up and took it. And so that critical statement certainly should have put trial counsel on notice that not only Dennis had a gun, but he had a gun out and aimed at Mr. Charles. And beyond just those 2 statements, we have the voluntary statement from Natasha Walker. Trial counsel had this statement early on in the discovery process. This statement, unlike Jaquan, who trial counsel describes the biases in terms of Jaquan is Dennis's cousin, Jaquan was involved, and indeed Jaquan was trial counsel's third-party culpability, the person he pointed to. Natasha Walker was much different. She had a prior relationship with Dennis, but she also had a prior relationship with Mr. Charles. They grew up together, they knew each other in the neighborhood, and she describes seeing Dennis and Charles walk down together. She describes a shot going off, Jaquan being on a bicycle at the end of the driveway, never leaving that bicycle. She never puts a gun in Jaquan's hand, but she puts a gun in Mr. Charles's hand. And that alone, in combination with the other statements, should have prompted trial counsel, put an obligation on trial counsel to have this meaningful consultation, this conversation with Mr. Charles about self-defense. And another thing that trial counsel had was the ballistics, the firearm evidence in this case, because we know that, or trial counsel knew that the bullet that killed Dennis was not fired from the gun that Dennis had, the gun that Jaquan then eventually took and fired at Mr. Charles. And so in the very least, trial counsel was aware that there was a second gun. And certainly based off of all of the evidence in this case, trial counsel had a responsibility to investigate the circumstances of the case and to counsel Mr. Charles about viable defenses. And we submit that trial counsel's failure to consult with Mr. Charles regarding the viability of self-defense was a failure to investigate it as a potential defense. Now, in our briefs, we point to 2 rules of the Connecticut Rules of Professional Conduct, which we believe are important and particularly relevant for this case. The first is Connecticut Rule of Professional Conduct 1.4, which places an obligation on counsel to consult with a client, to talk to a client about available defenses. But further, and most importantly in this case, is Connecticut Rule of Professional Conduct 1.2. Because as we noted in our brief, were counsel to meaningfully consult with Mr. Charles about self-defense, and were they to decide that this was a defense that they were going to pursue, Mr. Charles would have needed to plead guilty, or admit guilt at least, on 2 of the charges that were lodged against him, because he wasn't simply charged with murder, he was also charged with 2 different gun counts. And so in order for Mr. Charles to assert self-defense in this case, he would essentially be pleading guilty to those 2 gun charges. And that's something certainly that would have been Mr. Charles's decision to make, of course, after consultation with the lawyer. But it would have been his decision on which plea to enter. But as we discussed earlier, trial counsel admitted during the habeas trial that he did not investigate the viability of self-defense. Now,
Counsel, it seems to me that if the court had credited your client with, in fact, having had that conversation with Attorney Hussey, that you might have a stronger case with respect to the obligation to investigate and pursue that defense. But in the absence of that, doesn't, I guess I can't see why third-party culpability theory is not within the realm of a viable theory, given that the self-defense theory, in the absence of a finding that there was clear evidence of self-defense and or at least a conversation with Attorney Hussey, why the theory that was taken wasn't within the realm of effective representation.
Yes, Your Honor, and I think I would agree generally that yes, the choice of which defense to pursue is a strategic choice. But trial counsel's decision in this case to go with the third-party culpability claim and to reject self-defense can't be considered a trial tactic because it wasn't an informed. Oh, I'm sorry, Your Honor.
I just question whether or not he actually rejected self-defense if in fact it wasn't something that was clearly before the attorney. But perhaps you can address that on rebuttal. Okay.
Yes, Your Honor.
All right. You have 5 minutes, correct? You asked for 5, so.
Yes.
You can hear me, okay?
I can hear you, Your Honor, but I unfortunately can't see any of the hands, so I don't know. I'm sorry, I don't know.
I should clarify. The hands are not virtual hands; they are actual hands.
Oh, then I apologize, Your Honor.
That's okay. That's quite all right.
I don't see anybody.
Can you not see our faces?
I cannot, Your Honors.
Oh, I did not know that. That's important. We can see you. Is there a reason? Do you not have the capability of seeing us?
No, I do, Your Honor. I have the the little circles with your initials in them. It was my impression that you had simply turned your cameras off, and I certainly wasn't going to instruct you to turn them on.
Oh, I'm so sorry. Well,
and I was holding up signs for the time, so you wouldn't have seen them. I apologize.
Oh, I can see you now, Your Honor.
You can. Can you see all of
Judge
us?
Alexander.
Okay.
Okay. I guess
when we talk that you can see us?
I can, yes. Well, before I couldn't see you even when you were talking.
Okay. Well,
I could certainly hear you.
I suppose perhaps what I can do is, and you can't see you can't see counsel either, right, Attorney Brody?
I cannot.
Well, at this point, perhaps if if Attorney Brody can continue, I prefer that you can see everyone. But
Your Honor, this is Lori.
yes, yes.
What if
Lori,
she
your
clicks on the 3
suggestion?
buttons on top? The 3 dots?
Yeah, can you go to the very top of the bar, the toolbar up there?
And there should be the gallery part.
Yeah, that's a good idea. See, there's 3 dots where if you take your cursor and
Yes.
okay, click on that and
Yes.
see if if you click on that, there might be a gallery function. Do you see anything like that?
I don't, unfortunately.
Do you see a together mode? Do you have a drop down list? Do you click if you're clicking
I
on it?
do. Yes, it's show device settings, show meeting details, enter full screen or keypad.
Really? Okay.
I'm not sure. But I don't need to take up the additional time for it.
Okay, well, just let us know. I guess what we will do is that we'll continue on, but if there are questions by the panel when you're back on rebuttal, that we'll just interrupt you, okay?
I would appreciate that. Yes,
okay?
thank you.
We will also give you a verbal warning with respect to your time, okay?
Thank you.
I apologize. I wish we had known that.
No, I apologize for not speaking up earlier.
It's okay. All right, Attorney Brody.
May it please the court. From the state's perspective or the commissioner's perspective, Attorney Hussey was, when he formulated tried to formulate his approach to the defense, assessed, as we all know, the various verbal and written statements of the parties. And he explicitly testified at the habeas trial that he rejected a self-defense claim. And he said he did that because, as the habeas court said, there were no real building blocks that he was presented with at the time. What was absent, and this is important, what was absent from the 3 accounts that the petitioner gave to the police was that he in fact had a gun, that in fact he felt his life was endangered, and that he felt that a deadly physical force was the way to respond to that danger. And I think it's important to, if you look at all of those, my friend here tries to portray these 3 accounts as somehow an 18-year-old in search of the truth. But really what we have here is a drug dealer and a felon giving a series of completely exculpatory accounts, and he changes those accounts not sort of his own volition, but he changes those accounts after the first one when he denies all involvement, and the police officer says, well, you were there and you were outside of your car, and says, okay. Then he talks to mom. He gives another account, and then at that account, he attributes the shooting to fellows from Uptown, and then he doesn't then switch to seeking the truth again. He has to be prodded, obviously, by the police officer, and these are all in the police reports, who says, he says, well, there were 3 people at the scene, and you were one of them, and you're lying. Then he comes up with the final account, which essentially meshes with the third-party culpability account, in which he attributes the death of Dennis to sort of unknown shots. And I want to emphasize a couple of things. And so the absence of really the building blocks of a self-defense claim is something which Attorney Hussey would have understood, would have relied on, even assuming that the petitioner had told him about this 4th account, because this 4th account would have therefore been completely at odds with the prior 3 accounts. And the state's position is that essentially it would have portrayed the petitioner as it's a problem for both defenses. That's why I argued they were both weak defenses, but it's a particular problem for the self-defense claim. and it depicted the petitioner as really a liar. And I wanted to point out something really important, which is that counsel said that he felt cornered, but presumably somehow as an indicator that his life was threatened. But that only came out. He only said that in his trial testimony. Cornered is not in any of his police statements, and I think that's important. And so what you have then is, in order to raise a self-defense claim, you would have had to have had a fourth account, at least for self-defense, in which it would have had to have mirrored what he purportedly told Hussey at the habeas trial. I apologize. I indicated at one point in my brief that he didn't do that, but in fact he did. But I would assume that it would have been a very, very sort of risky endeavor. And I wanted to point out that at trial, the prosecution made hay out of the changing stories, and the petitioner admitted to lying to the first two, literally admitted to lying. So Hussey was really had a real problem with both the self-defense and third-party culpability, because with respect to third-party culpability, although it meshed with the third account, which is in his police statement, it was at odds with his first two accounts, which essentially completely exculpated him. And obviously the third party, the third account inculpated him as well. So I would argue that, and there's another thing I think, which I think we can assume, since Attorney Hussey read all those statements, there's something that's really kind of jives with the absence of the building blocks of the self-defense claim, which comes from Jaquan. So if you read Jaquan's statement, Jaquan describes the behavior of Dennis, who's the victim. And he says, he knew that Jaquan was watching from the end of the driveway, and he said, well, I knew there was going to be a fight. With one hand, I think he said with his left hand, he put it up to the petitioner's chest, and the other hand, he made a fist. So that, to me, is a sort of a very difficult starting point for Dennis actually posing a threat of deadly physical force to the petitioner, although later on, the petitioner does say that Dennis drew out a gun, but there's a contradiction there. And I think that's incredibly important. And I think what's really interesting is if you look at the habeas testimony, at the habeas trial, and you look at habeas counsel's final argument at the habeas trial, counsel says, well, with respect to self-defense, maybe Hussey could have somehow convinced the jury that with the raised hand, Dennis actually had a gun at some juncture. Because don't forget, all we know from the various police reports, at least prior to trial, is that the gun was pointed downward. Although the petitioner did say in his last statement that he did draw a gun. So I would argue what you have here is two weak defenses. And when you have two weak defenses, it's counsel's strategic choice which one to take. And I would argue that this really isn't this. And so my friend here says, well, look, all the cases that I've cited don't really address the question of an investigation. But really, this is not quite an investigative case. This is really sort of what is counsel going to use with the information that he actually does have. He's not trying to discover anything, unless you're saying that what he should have discovered is this fourth account, which he gave at the habeas trial. But counsel would have rejected that. And he said that because whatever that fourth account was, it was inconsistent with the prior accounts and was most consistent with the third-party culpability account. And that is a reasonable strategic decision that counsel can make. I wanted to sort of also say,
Attorney Brody, could I ask
Yeah.
you a question, please, about what you just were discussing? And that is it your position that when it's self-defense, when the claim is a failure to investigate self-defense, that's somehow inherently different from another type of defense, because presumably you rely mostly on your client for the information you need to present that self-defense, or am I misreading where you're going?
well, I'm not quite saying that, because I think my friend here is right, that counsel doesn't have to end with what his client tells him. So it's tricky, but clearly counsel was aware of the limitations of his self-defense claim. And I think that's important. And Hussey said something at the habeas trial, which I think is also important, which he said, I believe this third account. He said, I believed him when he said he was engaged in a tussle over the gun and shots rang out. And that's something to take into consideration. After all, who is best placed than his attorney to assess his client's credibility, particularly if you weigh that third account with having to present, in fact, a fourth account. So I can't give you a complete answer to that. And I understand the jurisprudence, which says that, look, counsel is not expected to investigate things which he can't possibly know about. But this isn't really quite that case, because counsel was aware of the possibility of self-defense. He just didn't think it really was viable. And I think when he said it lacked the building blocks, I think that necessarily implicated all the prior police statements in which those building blocks really weren't created, and therefore he had to present this fourth account. And I would also argue something else, which is, and I think it's obvious, which is that a self-defense, look, really what the evidence shows is that the petitioner shot this guy. That's really, and that's the state's case. So, and that's the strongest evidence in this case. And that's the problem, which you have two weak defenses and pretty good state's evidence. So, you know, Hussey had to sort of maneuver around that. And I think one of the things that's come up, which we've talked, which the briefs have kind of addressed, is this notion of what do we do with self-defense, in which it's a justification defense. And what that means is you have to admit guilt regarding the charges, which includes the gun charges. And what self-defense is, it says, well, I did it the way it's charged, but excuse me, I'm not subject to liability because it's self-defense. So it puts the gun in the petitioner's hand. And yes, Judge Elbow.
It occurs to me, and maybe this is kind of a common sense, and maybe not, but it seems to me that if someone has a viable self-defense claim, and in fact that's what happens, is it not usually the first thing that one says is, I did it in self-defense? I mean, maybe I'm wrong. Maybe there's just all kinds of variables, but could that not really figure into how you weigh the strength of a self-defense case, or is it not?
Well, I can't really. I think that the panel has much more experience with this than I do, frankly, as judges and as advocates. So it's not clear that I can really, and I'm not in a position to really answer that. But one thing that occurred to me in reading the various police reports is that if really the petitioner felt his life was in danger, that would have been something which he would have said in his various statements to the police. Now, that's not a sort of a completely supportable argument. It just occurs to me as I was reading it, that is something that would have come to the fore. And it's only really at trial, much later on, that he says, I was cornered. don't forget, this is his friend, and his friend takes out a gun, but we don't really know how threatened the petitioner was to the extent that he felt that his life was in danger. And that's the key to the self-defense claim. And the third party culpability defense, I would also want to point out to the court. So my friend says, well, the self-defense claim would have required the state to disprove self-defense beyond a reasonable doubt, and that would have made it sort of more appealing than the third-party culpability defense. But really, what is third-party culpability? Third-party culpability evidence is evidence which undermines identity, and the state has to prove identity beyond a reasonable doubt. So essentially, I don't see there really is much difference between the two, and really, in the end, the question of a gun charge would have been admitted with respect to self-defense, because you have to admit to everything, and the charge covers using a gun. And with respect to, it would have been really no difference with respect to third-party culpability, I don't think, because it's either complete denial or complete acquittal. With respect to the guns, I think it would be a wash. But I don't think, sort of in terms of proof, they're really any different. I just think that, Hussey was faced with a problem, which is that really the petitioner comes off as a liar, basically, as the prosecutor argued at the trial, and it really served him better to take the third-party culpability defense. And there are a couple of things I want to point. I'm not saying that the third-party culpability defense is a great defense. It also had problems, I would acknowledge, but let's remember that if you look at that defense, Jaquan says that the petitioner had a silver gun in his hand, but it's hard to figure out how that would actually work out. But if you actually look at trial, Jaquan on cross-examination backs off that and says, well, maybe on direct, he says, well, yes, it was a gun. And then on cross-examination, he says, well, maybe it could have been a cell phone. So, each defense had its pluses and minuses, I would argue. And the fact that the petitioner had to admit to the charges in order to raise a self-defense claim, I think, kind of pushes the balance over to the third-party culpability defense. I've cited a couple of cases. It's not clear to me whether my friend here disagrees with the notion that if the defenses are actually weak, that it's a strategic decision, and therefore it would have been up to Attorney Hussey. I think if I understand the claim is that the investigation was deficient, and really we don't have this weighing of two weak defenses. We really have a stronger self-defense claim, which the state believes is not actually accurate. It's not as if whether Hussey sort of elicited this from the defendant's lips, or whether the defendant or the petitioner told him that. He had clearly rejected that defense because there wasn't a viable basis in the prior police reports. And those police reports, if the defendant then changed and gave a fourth story, and I believe I'm repeating myself, would have portrayed the defendant as even a greater presenter of apocryphal accounts. And I don't really think, unless there are other questions, I have anything else to add. So the state would rest on its brief.
All right, thank you very much, Attorney Brody. All right, Attorney Moreau, I was hoping that we might be able to get some IT assistance. Is it true that you still cannot see us? Oh, now we can't hear you, but you need to just unmute yourself.
I apologize. I can see you right now, Your Honor, but for some reason, as soon as I start talking, all I see is just the initials and the squares.
Okay. Okay. All right. Well, why don't you go ahead and again, I would remind my colleagues that we just need to verbally interrupt and also verbally give Attorney Moreau her time. So thank you very much.
Thank you, Your Honor.
Go ahead.
I'd like to begin by getting into the question about whether this was simply a trial tactic, whether trial counsel simply disregarded self-defense as a trial tactic. And like I said, generally speaking, I would agree that the choice of defenses is a trial tactic. However, in order to disregard a defense, it needs to be investigated. And in this case, investigation into the viability of self-defense was critical for this investigation, was meaningful consultation with the client. And of course, different defenses may require different things, but as a baseline for self-defense, in order for trial counsel to investigate its viability, he needed to have a meaningful conversation with Mr. Charles. And I'd like to get back to the idea that Mr. Charles, and a drug dealer and a felon, should have been free to admit what he had done to the police. And I just think that's simply, well, it's just not what we see. Mr. Charles admitted, yes, he was selling drugs at that time, but he's still an 18-year-old kid living in Hartford with his mom. You can tell from his police interviews, at one point, he in fact asks to talk to his mom. He's scared. This happens often. We see it often in police statements that the first statement denies everything completely, and it inches closer and closer to the truth. And I think, moreover, what the requirement that trial counsel have a meaningful consultation with Mr. Charles, why that's so highlighted in this case, is because of the fact that Mr. Charles was an 18-year-old kid who's understandably terrified because he just shot someone, not just anybody, but his friend. And so meaningful consultation in this case would have given Mr. Charles an opportunity to explore, to determine whether he was going to tell the full truth on stand. It would have given him an opportunity to talk about self-defense with his lawyer, to talk about whether he should plead guilty or he should admit to the gun charges to assert self-defense. But none of that happened. None of that consultation happened. None of those discussions happened. And because of that, there was not a meaningful investigation into self-defense. There was not an investigation into its viability before it was simply rejected. Not to belabor the points, but this case truly called for self-defense based off of Natasha Walker's statements, Jaquan's statements putting a gun in Mr. Charles's hand, a one-on-one, hand-to-hand confrontation between these two individuals where one of them ends up shot. The discovery evidence did make... Oh.
You have 2 minutes. I'm just letting you know.
Thank you, Your Honor. The discovery evidence did make it clear. And despite any statements Mr. Charles may or may not have made, which this court does not need to find, trial counsel had an obligation to talk to Mr. Charles about the evidence that made clear that Dennis was armed, he was angry, and the aggressor in this physical altercation. Given Mr. Charles's young age, the clear facts, the witness evidence, meaningful consultation was necessary. But that wasn't done. And because it wasn't done, Mr. Charles's right to effective assistance of counsel was violated. And because of that, we would ask that this court vacate the conviction and order a new trial. Thank you, Your Honors.
All right. Thank you, counsel, for both of your arguments and your patience with the technology. I can say thank you for participating in this virtual hearing, and I'm sure you, like all of us, are very much looking forward to when we're returning to our regular courtroom. But until then, we will be taking this matter under advisement.
Okay, so we all know, of course, that they decided to grant his right to have this commutation hearing, and we're going to briefly look over the court filing just so you can have a little bit more context. And then we're going to go into the actual commutation hearing. How did you feel that hearing went. I think that it's, it's interesting. It's the same attorney that's still representing him. She's still battling for him. I thought she did a good job. I thought that she certainly had more energy than the DA that was standing up, kind of, fighting against the case. In my opinion, I think she has a point. I think that the self-defense aspect of it seems to me that it should have clearly have been an option, and that his attorney, the classic inefficient of counsel, whatever. But let's just read this, and then we can jump into that. So on June 28, 2007, following a jury trial, a petitioner was found guilty of murder, a violation of general statutes, carrying a pistol without a permit in violation of general statutes, criminal possession of a pistol, and possession of narcotics. In August 29, 2007, the trial sentenced the petitioner a total effective sentence of 48 years of imprisonment. The petitioner's convictions were affirmed after the appeal. So, in the late afternoon, September 25th, 2004. Oh, so I read this wrong. It didn't happen in 2008. It was 2004. The victim, Dennis Faneuil, and his cousin, Jaquan Faneuil, were riding bicycles in residential area of Deerfield Avenue in Hartford. The defendant was close friends with the victim, was driving in the area, and the victim signaled for him to stop. The defendant parked his car a short distance from where the victim, Jaquan, were then standing, and exited his vehicle. Jaquan remained with the bicycles at the end of the driveway. The defendant and the victim began talking and walking up the driveway towards the rear of the house. The victim demanded a cellular telephone that the victim's brother, then incarcerated, had entrusted to the defendant. The victim's brother had instructed the defendant to keep it away from the victim. The cellular telephone was valuable because it was used in the illegal drug business and contained the contact numbers of the numerous customers. Okay, so this is what they were arguing about. For some reason, when they brought up a cell phone, I thought they were arguing about like a girl, and they wanted to see if he was texting or something. That was like the first thing that came to my mind. But when the defendant refused to give it to the victim, the two men began arguing, and the victim made a fist with his right hand as if preparing to hit the defendant. At that point, Jaquan moved away from the bicycles. The defendant fired one gunshot, and the victim was hit in the abdomen with a bullet from a 9mm semi-automatic firearm. He later died from his injuries. So they state the facts of the case, of course, to be completely different from the picture that was just painted. They claim that there are eyewitnesses. She's basically claiming that this entire thing is wrong. This is not how it happened. And what actually happened is that the victim had pulled out the gun. He had taken it and shot him. There were eyewitnesses that could have validated that, but his attorney never allowed him to take that defense, so no one heard about it. That's pretty interesting if it's true, right? Now, the defendant fled the scene with a silver gun in his hand. Jaquan ran to the victim, who had fallen to the ground on his knees, and took the victim's .38 caliber revolver from him. He chased the defendant and fired 5 gunshots at him. Wow. After he failed to hit the defendant, Jaquan threw the revolver in the trash can behind one of the neighborhood houses and went home. The defendant just went home. The defendant, while being pursued by Jaquan, caught his gray shirt on a fence. He jumped over the fence. He managed to slide out of the shirt and left it behind. The police officer later retrieved the .38 caliber revolver, the gray shirt with the Pepsi Cola in one of its pockets, and a cellular phone within the area traveled by Jaquan and the defendant. The police did not find the 9mm weapon. During the investigation, the police interviewed a witness. I mean, this story is just totally opposite from what she's saying happened. During the investigation, the police interviewed a witness to the incident. Tasha, a former girlfriend of the victim, was standing outside of her grandfather's house When she saw the victim, Fennell, riding up to the street on a bicycle, she also saw the defendant wearing a gray shirt. She stated that Jaquan was still at the end of the driveway with the bicycles when the gun was fired. She then saw the defendant run from behind the house with the gun in his right hand, and she heard additional 4 or 5 gunshots shortly after. The petitioner initiated in the present habeas petition on March 8, 2013, in his amended petition filed on April 2019, the petitioner claims that his counsel attorney, Hussey, was ineffective, that's what I was looking for, in failing to fully investigate the viability of self-defense as a potential trial defense. The failing to assert that the self-defense theory of the petitioner underlying criminal trial, the respondent filed a return of April 15, 2019, generally denying the petitioner's claim. A trial was held on May 30, 2019, which attorney Hussey and petitioner attorney Brian Carlo, petitioner expert witness, testified, both parties present. So, effective assistance of counsel. I don't know. I don't. It's funny because in here I don't see anything that supports what she said, but maybe you wouldn't expect to see it in an appeal like this. You just have to take her word for it. But because I don't know. There's a strong presumption of trial strategy employed by a criminal defense counsel suitable as a result of exercise. I don't know if they'll bring that up here. Because I guess for some reason I thought that he used the victim's gun on the victim. Is there proof that? Did she mention what bullet he was killed by? And does that make a difference? Is it self-defense if the victim pulls it out his gun first? Yeah, I guess so. So maybe it's, but and it is possible that happened. Certainly, it's easy to believe that. There's there's another thing here that Richard showed. This is, it's just, I guess, amplifying even more how much violence these guys, their kids, have been through. This is they call it a cold case, Kevin Johnson. So they solved a murder and a triple shooting. They solved this 2 months before this incident. But basically it goes through that this man had done a drive-by shooting on the victim and also our friend Jared, and they were shot. So it's just showing how much violence they've been through. But if you want to get a peek of what Connecticut looks like, let's go watch this.
In the afternoon, and Kevin Johnson and his good friends riding on Norfolk Street in the Blue Hill section of the city of Hartford. Kevin's being driven on Kent Street toward the intersection of Albany Avenue. The driver of the car is an individual known as Donald Rayner. As the car is proceeding down the street, a second vehicle pulls in behind. In that car are several black males wearing baseball hats and dark sunglasses. They all have handguns. As the car gets to the intersection of Albany and Kent, it pulls over. The second car pulls next to it. The men in the second car fire several shots into the car. They strike Donald Rayner several times in the legs as he tries to flee the car. Kevin Johnson is shot in the right side of the back as he tried to flee the car. He has a graze wound on the head, and he's shot in the right thigh. He falls right on the pavement. He's unconscious almost immediately, and the second car drives off west on Albany, out of sight.
There were a number of other people in the car, most of which are convicted felons. Some have died through murder themselves. Most of them were pretty bad guys. Kevin was not the intended target. That maybe one of the other occupants that were inside was the intended target. It could have been gang related.
Police have several witnesses that give them a lot of information in the initial part of the investigation, and they're able to identify several persons of interest. But that's as far as the cooperation went. People didn't talk after that.
This potentially could have been 3 fatalities. Instead, Kevin lost his life and 2 other people were shot, but fortunately lived. due to the severity of this case, we're hoping that people really will pay attention and come forward and help us.
It's been over 11 years since the murder of Kevin Johnson. He was 2 days short of his 19th birthday. When he was shot, the intersection was full of witnesses. There are a lot of people who saw the crime. Hartford police know that. The Hartford police need anybody who saw the crime and members of the community who have information to give it to them, come together with them to solve this murder. Kevin was a young man, died a terrible, violent death, and it's time to solve the case. I'm Chris Lyons.
Okay, and that case was solved. Again, this is nothing. These weren't. It was just our victim, and also the men who's standing up right now for the commutation hearing were victims of this crime. So that's what I was showing it. Just want to reiterate it. It has nothing to do with what we just read or what we just heard. So with that, let's jump into the commutation hearing, and we'll unpack it after that. So let's go.
With the board's permission, you may proceed to explain why you believe you deserve relief. If you have an attorney, you may have them address the board after. The decision is yours.
Dear members of the board, before I start, I would like to thank the board on behalf of myself and others for this opportunity. You all have turned prison, a dark place full of disbelief, anger, and depression, into a place of grace, hope, and second chances, because the board has shown that rehabilitation and growth does matter. My name is Jared Charles. I'm 37 years old, and I've been incarcerated since the age of 18. September 25th, 2004 wasn't only the day that my life changed, but also the day the lives of others changed as well. I would like to give my deepest and my sincerest apologies to the family and loved ones of the victim. I believe parents should never have to bury a child, and I'm extremely sorry and I'm remorseful for my actions, but for also not having the humility, the maturity, skill, or know-how to mediate this situation that I now realize just didn't have to be. I was brought up in a single-parent home along with an older brother. At just 5 years old, my father passed away, which didn't just have an effect on me emotionally, but also had a negative impact on my thought process, decision-making, and childhood. The passing of my father put a sadness and pressure on me to grow fast and financially contribute to help my mother. Having to grow up watching my mom struggle as a single parent always made me feel helpless, and I would have done anything to just give my mom some relief, help, or make life a little less difficult for her. I just want to say that my imprisonment is not at all an indictment on my mother or how she raised me. Not only has my mom sacrificed and nights went hungry for us, she worked hard to keep a roof over our heads and has never cheated to get by. My mom has been an example of perseverance and has raised me to follow rules, show respect, and to not engage in negativity to prevent me from being in situations like this. Still, it wasn't easy being raised on the north end of Hartford. Since a youth, I've been exposed to drugs and violence, not just in my neighborhood, but also in city parks and even to and from school. Bad influences surrounded me, and I was young, immature, and impressionable. And with the pressure that I put on myself, I conformed to those bad influences. Honestly, it's shameful and it's embarrassing to admit and know that I ever gave into and was manipulated by those influences. I feel tricked, I feel misled, lied to, and taught wrong. It was all a false sense of contribution and being the man that I thought I had to be because I was still young, uneducated, with no sense of direction, with no people or working skills. I was trapped. Throughout my 20 years in prison, I've grown up a lot. Although I received 16 DRs coming in at 18, immature, and entering a jail setting, it wasn't easy getting to know myself. After a lot of reflection and looking at my life as a false narrative, I decided to develop new values, new direction, and a renewed mind. By my 9th year, the ticket slowed. I got into spirituality because I believe a renewed mind started there. I've gained great knowledge and understanding of my faith, and I've allowed what I've learned to show in my character. Growth also comes with education. I decided to get my GED. It was my very first accomplishment. It wasn't exactly how I dreamed about it, but I graduated with my mom watching, which meant a lot to me. Being in the cap and gown, having my mom see me do something positive, pursue education, and taking a step towards change was a proud moment for me. It was when I realized I could do anything I put my mind to. I've completed vocab classes, such as computers, which taught me how to type and operate electronic devices. I've also completed anger management, cognitive awareness, which was new to me. It taught me faulty patterns and faulty behavior, how to recognize them, and how to take control of them. I've also completed Puritan, Tier 2, and I facilitated the Tier 2 class as well, and completed the AVP program. That was the most surprising to me, and has done the most for my growth in mind state. It was exactly what I was looking for. It taught me humility, how to be understanding towards others, how to keep a calming energy, and conflict resolution. I've been recognized and acknowledged for my charitable donations to the St. Vincent de Paul Shelter, I'm currently one lesson away from completing my psychology classes from the College Guide, and I'm currently in the CTVIP program, which helps with dealing with trauma, mentorship, and helps with reentry regarding jobs and housing to those who may be in need of it. I've had janitorial jobs. I worked as a patient care assistant, and because of that, I worked in a mental health facility where my job was to take care of the unit and the people housed there. I'm right now currently in the honor unit where I was chosen to be here because of my example and good behavior. The honor program will provide education, programs, opportunities, and to better development and rehabilitation, also reentry. I also work in maintenance. There I do plumbing and HVAC, but I specialize as an electrician. With no skill, knowledge, training, or schooling of any kind, I landed an interview and received the job. I did that by going to the library and having loved ones send me in information to better my knowledge as an electrician, how to succeed as one, and the business side of it. With my electrician knowledge, I can and I will impact my family and community with what I've learned. My electrician skills gives me a career so I can become a taxpaying citizen. It also allows me to build a business and work for myself, and even teach and employ others. To teach others all I've learned doesn't just give them a job, but a career path as well. And it is my obligation to positively contribute to my community. So I will volunteer at the local YMCA to help mentor at-risk youth. I already have nieces and nephews that attend camps there and after-school programs. So to give back in any way that I can isn't just my responsibility, but it's an expectation of mine. Through this, my support system has been just that and more. Supportive mentally, emotionally, spiritually, and financially. Hearing their compliments of how proud they are of me has been encouraging and very motivating. It's been my desire to visually show my family all that I've learned and the man that I've become. I've earned their respect and their admiration, even in these circumstances. Throughout this process, I went through every thought and every emotion pursuing rehabilitation. For every denied response or bad news received, it makes it very easy to get careless, feel defeated, hopeless, or angrily give up. You look around and you see guys that's been here 30, 40 years, and you can't help but to ask yourself, is this my future? You start to wonder if the road to rehabilitation I'm on matters to anyone or who really cares about it. But I didn't quit because rehabilitation is something I did for myself. I wanted to continue to live in truth, regardless of my circumstances. I came in young as a teen, prideful, immature, lost, misled, uneducated, trapped with no skill or direction. Today, I'm proud to say that person has been long gone. When I was a child, I talked like a child, I thought as a child, and I reasoned like a child. When I became a man, I put the ways of childhood behind me. I do believe the best apology is change behavior. And regardless of my growth and maturity, a very loved and important person in life was lost. I would like to say again to the family and loved ones of the victim how sorry I am for my actions and for having to relive it. Although I can express how sorry and remorseful I am for my actions and the pain that I caused, I do hope to have your forgiveness. Words can never explain the shame and the regret that I feel within myself and will continue to carry with me. To the Board of Pardons and Parole, I would like to thank you again for this opportunity to speak, as well as this opportunity for redemption. I pray that you see the change in me and the vision that I have for my life and for my future. I also would like to thank my attorney, Ms. Kara Monroe, for her assistance, words, and belief in me. Thank you, and God bless.
Thank you for your statement, Mr. Charles. Can we ask for his attorney to introduce herself? Oh. Attorney Moreau, can you please introduce yourself?
Hi, yes, this is Kara Moreau.
You may now speak if you have a statement.
Thank you. Yes, I do. So I want to start by thanking the members of the board for this opportunity to speak with you all. I guess I should start by saying I don't normally do this type of work, but it was really important to me to help Jared with his application because I don't know of many more people more deserving of a commutation, more deserving of a second chance than Jared. I first met Jared about 6 years ago in early 2018 when the attorney I worked for at the time, Richard Reeve, was appointed to represent Jared in a habeas case. Attorney Reeve and I then tried Jared's case together, and I continued working with Jared through his subsequent appeals through the appellate court. What has always been remarkable to me about Jared is that for someone with such a lengthy sentence, a sentence that was handed down to him at such a young age, Jared is not a bitter person. Instead, he works hard every day to educate himself and better himself. And most importantly, it became very clear early on to me in our relationship that Jared treats every person he meets with respect, understanding, and patience. And when you get to know Jared, it becomes obvious that he does these things not because he thinks it's something he has to do or because he thinks it will gain him some kind of advantage. He does these things because that is who he is. He is someone who cares about bettering himself and someone who cares about how he makes other people feel. As you all know, Jared was just 18 years old when he committed this crime. Now, I won't ramble on about the scientific developments we as a society have learned about brain development and the circumstances of youth, because I know you're all very well informed on this topic. But I, of course, think it's important to know that Jared is no longer 18 years old. He has done an extraordinary amount of growing, maturing, and rehabilitating himself over the past 20 years. And as he writes in his letter, he takes full responsibility for his actions. He deeply regrets the harm he caused. As Jared told you, he was chosen to be housed in the Honor Unit at Cheshire, which is a specialized program to provide opportunities for those with exceptional behavior because of his exceptional behavior and his exceptional rehabilitation. In addition to engaging in work, education, programming, and religious services, Jared has begun taking college classes. His goal is to become a college graduate, and I have no doubt that he will accomplish this goal. Finally, I would be remiss if I didn't note that Jared has put forth a truly admirable effort to maintain a close relationship with his family, despite his incarceration. As I was preparing for this hearing and reviewing the materials that were submitted, I was reminded again just how many members of Jared's family and friends reached out to me to ask to write letters of support to the board. I know you've all read them, so I won't repeat everything they say here, but I will say this. It is no coincidence that most of them echo the same sentiment. Jared is the kind of person that even when things in his own life seem dark, he makes every effort to be a light for others. I respectfully submit that Jared's current sentence did not take into account the full circumstances of his youth and his vast rehabilitative efforts. I urge the board to give this very deserving person a second chance at life. Thank you all.
Thank you both for your statements. And as your attorney just stated, we have thoroughly reviewed all of the submissions on your behalf and documents from the time of the offense through now. And the court documents, all of your records within the facility, your accomplishments, we've reviewed it all, the letters that were submitted on your behalf. So we are very aware of all of your circumstances. We do have questions for you, sir. And when we're done with our questioning here today, we do not have input from the state's attorney's office, and we'll verify with the Office of Services, but I don't believe we have a statement from them either, but we'll deliberate at the end of our questioning and we'll give you our decision here today, okay?
Yes, ma'am.
We'll begin with my colleague, Mr. Pohl.
Thank you, Madam Chair. Good morning, Mr. Charles.
Good morning, sir.
How are you?
A little nervous.
To say the least, right?
Yeah, but I'm doing fine. Thanks for asking, but I'm a little nervous.
Good. So there's a few things that I want to go through with you. The victim in this case, and you know, I don't want to go through all of the details of what happened. It's been documented well, but the impact of what you did. I've heard you address it. I've read a little bit, that kind of thing. Can you talk a little bit about that?
The impact it had on me, you said, sir?
The impact that it had on people.
Well, as I said, he was a loved person. I'm sure it impacted them. I'm sure they was hurt by it. I was hurt by it. Being familiar with him and knowing him, I consider him a friend. I'm hoping something like this doesn't repeat itself anywhere or nowhere, especially within my community. But I'm sure it definitely impacted his family and friends because he was a loved person.
How do you think they were impacted?
I thought they were hurt. I thought there were a lot of questions that they had, maybe unanswered questions, maybe they had for me. But I'm sure they were impacted in a hard way where, you know, there was hurt there.
So how do you think his mom felt?
Being familiar with his mom, I know she was hurt. She was at every court date of mine. I haven't spoken to her, but I'm sure his mom was very upset. I actually remember her face as planted in my mind. It's hurtful to me, but I'm very sure it's hurtful to her as well, and I know how she felt about it.
So, there's nothing. I don't know that there's anything in this world that a person can endure that's greater than a mother having a child taken from them, especially through gun violence, right?
I agree, sir. I agree wholeheartedly.
So it's when it comes down to it, what she had to endure, and still does, it's incredibly important to really understand that and reflect on that in the best possible way that we can, right?
Yes, sir. I do want to say I absolutely understand that. As I said in my statement, I don't believe a parent should ever have to bury a child. I absolutely understand her pain. I absolutely understand her hurt. And this is why these things are shameful to me. My actions and the pain that I've caused others, my understanding of her pain and her loss and all she had to endure is exactly why I feel shame. It's exactly why I am apologetic. It's exactly why I said the things that I said in my statement.
Okay. I appreciate your reflection on that. And certainly, certainly that's important to consider, a couple of the things that you said, and I'll get to them when you leave prison,
Yes, sir.
You talked about disciplinary reports. It's been almost 7 years since your last ones. It's been over 10 years since you had any kind of physical altercation there.
Yes, sir.
How do you stay out of trouble?
Sir, just growth, growing out of a phase, learning new things. Staying out of trouble really comes from my own doing, who I surround myself with, and my mind state. But ultimately, it comes down to just growth and coming out and being out of a phase. There's things that I had to learn and develop coming in young, and the man that I am today, I had to develop these things throughout my time here being incarcerated. So as I learn new values, as I learn these new things through people who mentor me, through programming, I learn new things and I develop new values and I stay out of trouble that way, sir.
That's how we do it. It comes down to a choice, right?
Yes, sir. Absolutely.
In each situation we face every day, right? As you explained, how we respond to the world around us is a choice. And certainly the people that we put around us has a great impact on who we are and what we try to do.
Yes, sir. I agree.
So there wasn't a lot here when it comes to you and actual substance use. But you did, correct me if I'm wrong, there was a little marijuana when you were out there?
It was a little marijuana that I indulged with. Yes, sir. You're correct.
And since anything else?
Well, I took the Tier 2 program because marijuana is something that I've been involved with probably since a preteen. It's something that I've been smoking. I understand it's legal now, but for me here today, I want absolutely nothing to do with it. It's my reason for taking the Tier 2 program. Rehabilitation is, a lot of times people see it as behavioral things, but a lot of times we have to work on our addictions. Or for me, I had to work on my addictions, which came with my addiction to marijuana. And I had to fight that urge, and I had to beat it, and the Tier 2 program assisted me through that. And because of my efforts doing that, they allowed me to facilitate it.
So you did take Tier 2 and you did facilitate it.
Yes, sir.
I'm interested. So you said you beat it.
Yes, sir.
Did you really beat it, or did you learn how to live with it?
No, I would say, well, I mean, it's here. So I guess I technically, in the world, as I should say. So I guess I technically have to live with it, but my indulgence or my desire for it is absolutely gone. So that's why I use the phrase beat it, because my desire for it is just non-existent.
Why do you think that is?
Growth.
What kind of growth?
Those things are phases. I see those things as phases, dabbling in drugs and alcohol. Those things are phases, or a mind state, as I should say. My mind state has changed. My mind state is renewed. So I've completed that part of it. As an adult man, it is nowhere in my plans to indulge in drugs or anything negative. So to go back there would just be pointless or moving backwards. I beat it because it's no longer in my plan, sir. I have no reason.
What were you looking for? What were you looking for when you're getting high?
Probably a feeling of just calmness, or maybe relief of stress.
How do you do that now?
I pray. I pray. My faith tells me to pray, not to indulge in drugs.
That's and you met some people in Tier 2, right?
Yes, sir.
Some people who might have had it even a little worse than you, right?
Yes, sir. A lot worse.
Did you have the opportunity to, like, through mentorship, what were you doing?
Well, I've seen it as the same.
Facilitating. I mean, yeah.
Yeah, I've seen it as the same concept. Even though they may have been harder drugs, so to speak, than I, addiction is just that, a mind state. It matters who you surround yourself with, and it's just my job to kind of help them to beat their urges and how not to repeat certain steps that leads them back to those actions. Sometimes that be a crowd, just the people they hang with, and once again, their mind state.
So when you were facilitating, did you ever have anybody where the light bulb went on?
There's a couple of people who were there for the right reasons. There were a couple of people who felt like it was probably too late for them. But yeah, we have instances where a light bulb did come on for some people.
How'd that feel?
Felt great. I'm here contributed positively, and I'm here contributed in a positive way. This is great. This is something I felt like I was born to do. It's something that I always want to do. I feel like it's my purpose. I mean, taking somebody away from drugs can help save a life. It felt great.
Way different than when this first happened, right? In 2004.
Way different. Way different. Very different.
So the programming that you've taken a lot of other really good programming. Alternatives to violence was a big deal, and you had talked about that, and it was part of your application, certainly. The honor program. What's your role with the honor program?
I'm not one of the founding fathers of the program, but when the program first started, they went around and they asked people who they felt were qualified to be here. Even though I'm not one of the founding fathers, my job is to still actively mentor and just to make sure people are on the right track and people aren't necessarily impatient with the things that they want, which is extra programming, extra schooling. And these are things that this program provide, but I don't have a true title in the sense of this program. I'm just here participating.
So when you said that you surround yourself with people that are positive and doing the right things, is that what you found an honor?
Yes, sir. These are people who are older than me, who I just seen with just walk through here with a sense of joy, and always had a certain type of energy to them and always believed in doing the right things. That was something that I had to replicate. That was something that I wanted to be a part of. And those people have helped me greatly throughout my time in here.
Very good. You've done some work in the mental health unit. You talked about that. The electrician, the whole electrical piece, right?
Yes,
Where
sir.
you found something that really is vocation and something that you're good with.
Yes, sir.
To move forward, right?
Yes, sir.
So you also said, just along with that, just making notes as you were speaking with us, you said you feel obligated to positively contribute to the community.
Yes, sir.
Cultivated in while you've been incarcerated.
Yes, sir. Growing up, I didn't follow the best examples, and they were the wrong examples. They were the wrong things that I followed. The reason why I feel obligated, because this is how I give back. It is my obligation. It is my responsibility to give back the things that I've learned in here, which is a skill such as electrician, such as things like conflict resolution, keeping a calming energy, the same things that I've developed within these programming, because these are things that I didn't have or was taught when I was, or 20 years ago when I was 18.
That's important. I also find it pretty interesting that you quoted 1 Corinthians 13 this morning.
Yeah, yes, sir.
That's very insightful.
It's my favorite. It spoke to me immediately, because that's exactly how I feel.
I mean, and that's the hard part in so many of these cases, because you got babies that are, for me, babies, 18, 17, 18, that are out there and you don't know the meaning of life yet, and they wind up faking one.
Yes, sir. I understand that.
It's hard. So when you get out, just to check with you, living arrangements, how do you see that unfolding, like eventually here? How do you see that transition into the community?
As I said, I have a great support system. My mom, my loved ones, my wife, they've been here from day one in this moment. My living arrangements wouldn't be in Hartford, but it will be out of town. I'm not sure if it's necessary to say the town, but it will be out of town.
No.
All right, it will be out of town. But my living arrangements and my support system and my transition into the community, I don't believe it'll be difficult at all, simply because of my support system and the people who will be there backing me, along with my mindset and ambition.
I saw, you know, and I picked up on that with all the letters that you had from family and such. One of the letters, are you in regular contact with Mac Young?
Yes. Yes, sir, I am.
So he's out there doing the right thing after after a commutation.
Yes, sir. He's one of my mentors. He's exactly who I was talking about.
He's that's incredibly important that, you know, you can do positive things when it comes to it, right? So that was one of the letters that we received. And certainly he has a story of his own that followed parallel paths. So, you know, that it's important to have those positive people in place.
Yes, sir, I agree.
And the only other letter I really wanted to reference was, you know, as you put in to be a true mentor, Officer Moore had written you a letter of recommendation for that.
Yes, sir.
Where he really talked about who you are. And that's the thing. It's, you know, in an hour hearing or however long we get to see you in, you know, a written submission that makes it, puts you in the best positive light. The greatest thing that we can hear at times is from somebody who knows you on a day-to-day basis. You know, because that's really gonna show us what's there. So I appreciate you answering my questions this morning. And,
You're welcome, sir.
I don't have anything further to find out.
Thank you, Mr. Pohl. Good morning, Mr. Charles.
Good morning, ma'am.
So I do want to talk to you a little bit about the time of the offense. We won't go over the details, but the victim was a friend of yours, right? Or at least an acquaintance that you knew?
Yes, ma'am.
Yeah. And your families were friendly as well?
Yes, ma'am. I would say that.
Okay. Did you carry a weapon regularly at that time?
Yes, ma'am.
Yeah. And why was that?
Once again, just following bad influences. It was a lifestyle I was caught up in, shamefully enough. You do it for protection. You do it because, you know, living in North end of Hartford, especially at that time, you know, when you win a certain lifestyle, you know, any day, you kind of feel like your life is threatened. Only when you win that lifestyle. And that's the reason why I did that.
And were you also selling drugs at that time, sir?
Yes, ma'am, I was.
Okay. I wonder, do you remember what Judge Malarkey said to you at your sentencing?
I think he said he's only given me 48 years because of my age. Is that the part you're talking about, ma'am?
No. So right before he handed you your actual sentence, I'll read it to you. He said, I don't see any likelihood that the offender is going to conform his conduct to the requirements of society. I see none absent some incredible life change. It is depressing that he took such a young life and he is in effect forfeiting his own.
I
So,
actually do.
Go ahead.
I was going to say, ma'am, I'm sorry. I was going to say, I actually do remember that. I actually do.
Do you think you've made those incredible life changes that he referred to?
Absolutely, ma'am. I took the time, I put the effort in way before a commutation or anything would have been about. My reasons for putting the effort in and learning these things and learning new values and a renewed mind is simply, as I said before, to live in truth. When I was young, and I was on the streets doing these things, that was a lie. That was deception. That was falsehood. I actually equated to fool's gold. It was something that I bought into fool's gold. I decided that's not truth. And regardless of my circumstances, I am going to change. And I'm going to be a person that lives in truth and lives in positivity and pay it forward.
Okay. And you have done that. Can you tell us more about the VIP mentoring program?
Yeah, it's a new program. It's actually ran by two people who are just recently incarcerated. They come up here on a weekly basis every Tuesday, and we speak about trauma. They have a saying that says the only thing worse than trauma is trauma undealt with. And we go through there and we talk about the things that we experienced in life, the things that hurt us. They teach us mentorship. They're very close to the Yale programs and things out there in a certain town, and they help with finding people jobs and housing. I think they're very great to the community, and it's something that I want to be a part of, or hope to be a part of.
So are they training you to go on and mentor others in the future?
Yes, ma'am.
You also mentioned being a patient care assistant. When was that?
I want to say that was about 2017 to 18. That was some years ago.
And where were you at the time?
I was in the McDougal Correctional Facility.
Okay. And you were in the infirmary providing that care?
Yes, ma'am.
Well, I'm sure that's not easy work.
I'm an electrician. I deal with,
right.
480 volts and 270 volts, and that's actually more difficult to do.
Yeah. So is it your plan to get, I don't even know, licensed in electrician?
Well, I have to become certified.
Certified, okay.
Yes. Yeah. Unfortunately here, they don't do that, regardless of the work I do. So I have to go to school. My plan is to go to school. I have to go to school and I have to become certified in order to continue on with my plan.
Okay. Do you know what that looks like?
Yes, ma'am. My plan is to attend the Lincoln Tech. They have advanced classes, as I should say, advanced classes. I plan on taking those advanced classes to become certified because the knowledge that I already have within myself and experience with it and with using tools, I feel like I should take the advanced classes to challenge myself and learn more, or everything that I can learn.
And how long would it take you to get your certification?
I'm not sure. I think it's about 6 months to a year from how I heard about it. Maybe that depends on how good I am or how advanced I am or how I, maybe a test. So, but I heard it's 6 months to a year. Okay.
All right. Well, you did receive excellent evaluations for your work there and from program facilitators. So everyone had nothing but positive things to say about you. We did receive letters from your family members, your fiance or child, your mom. Have you been in contact with the victim's family?
Through third person, I've been in contact with a brother.
What's his first name?
Terrell.
Okay, that's your victim's older brother?
Yes, ma'am.
Are you aware that he sent in a letter in support of you receiving a commutation?
Yes, ma'am, I am aware of it.
Okay. How did you find out about the letter?
Through a mutual friend. Through a mutual friend. He actually told me, honestly, ma'am, I wasn't surprised by it.
You weren't surprised? Were you close to the victim's brother?
I was very close to him.
Okay. So how does it make you feel to know that his brother is gone, right? Is never coming back, but he supports the person responsible for that getting out of prison?
The feeling of that is unexplainable, honestly. The fact that he still support me, that he has the strength to be so forgiving. That's not something that's usually taught, especially where I come from. It's it's unexplainable. I honestly, I don't know what to think about that. I'm very grateful, very grateful. But his forgiveness is actually very inspiring.
Yeah, it sure is. We don't see that very often. We don't read letters like that very often. So yeah, it definitely is a huge message when we do receive a letter like that. You mentioned some family businesses, potential jobs. You have an extraordinary amount of support. I mean, it's rare that we see someone with so much support. So many people in your corner that it would make it almost impossible for you to fail should you be released. Yeah, the only way would be is if you didn't take advantage of all of that support. You know, you really have to utilize these people who are willing to go out on a limb and help you. But tell me about the businesses where you have potential jobs.
Well, I have friends and family that own, restaurants and stores and things in that nature. I have friends who are head of unions of certain companies, who are managers of certain companies. Finding a job, as you said, ma'am, would not be difficult at all. But it's definitely something that I will take full advantage of.
All right. Thank you for speaking with me, sir. I'm going to hand it over to my colleague, Ms. Page.
Thank you, Madam Chair.
Welcome, ma'am.
Good morning, Mr. Charles.
Good morning,
I just
ma'am.
have a few questions. And one of the things that I noticed is that although you admit that you committed the crime, you took this case to trial. Can you explain to us your mentality as to why?
Yes, ma'am. Sometimes those things are kind of brought about by counsel. Not to mention, I wasn't really too accepting of a sentence of 30 years. Honestly, I felt like the details of the crime didn't really require that. So that was actually my mind state during that time.
And so once the judge gave you the 48 years and then you have a few consecutive sentences, have you sought any other avenues for relief?
No, ma'am.
And my last question is, in a perfect world, you're requesting this commutation. What would you expect from us today in terms of commuting your sentence? Taking some time off, walking out of the prison doors? What is your expectation? A day, 2 days?
Honestly, ma'am, I'm just grateful for the opportunity. Just to speak, I'm just so grateful for this moment and the things that y'all acknowledged about me. I don't have any expectations. I think whatever the board does is what the board is qualified to do. I'm just grateful for the opportunity, ma'am. I don't have any expectations.
I appreciate that. I said I had one more question, but now this is my last question, and that is, so the premise on which you're seeking this pardon, this commutation, is
Yes, ma'am.
your good behavior, that you're compelling in your circumstances you're asking for this. Your good behavior there in the facility, and by your educating yourself and rehabilitating yourself, that's the premise for your requesting this commutation.
Yes, ma'am. Also, I also feel like if granted this commutation, I can be of service to my community. I can bring these new values. I can bring a new thought process if I do it to one person, that can snowball. I feel like along with those things, I feel like I could be of service with the things that I've learned and help bring those things back to my community, ma'am.
I appreciate that. I want to just congratulate you on your educational endeavors, and you really have turned your life around, and I'm appreciative of the effort that you put forth to rehabilitate yourself. And I thank you for speaking with me. I'm all set, Madam Chair. Thank you.
Thank you. Can we just confirm with the Office of Victim Services that outreach was done in this case? Ms. Hamlet-Williams, thank you so much for joining us.
Thank you, Madam Chair. Thank you, panel, for having me. I did speak with the family and outreach was done.
Okay, and we have no statement today.
No, ma'am.
Thank you so much.
Thank you so much.
Okay, so we have no state's attorney present. So at this time, sir, the panel will enter into deliberation. You can listen to our deliberation and we will give you our decision shortly. We'll begin with Mr. Paul.
Thank you, Madam Chair. When it comes to commutations, we're asked to look for exceptional and compelling circumstances. And for me, when it comes to Mr. Charles, I have found them. I found them in his understanding of what he's done, the way he has conducted himself in the last 7 years without a disciplinary report, in the last over 10 years without, what's the last fighting ticket, right? He has taken a great deal of programs and has risen to the level of mentor when it comes to tier 2. He's found himself in the honor program at Cheshire. And certainly that's about being able to take yourself out of the fray, out of the negativity, and put yourself into a positive place to go and succeed while incarcerated. He's done well with that. He had applied to be a true mentor in the past, which wound up with a very good letter from DOC personnel while he was applying for that. I know that it wasn't related directly to the commutation, but it spoke to the kind of person that Mr. Charles is. He's gone through and he's educated himself. One of the biggest things that we can measure in terms of reducing recidivism is how much people take in terms of programming and really processing it. He's done that. Education, he's done that, and he's really processed that. And he's helped others in that way. He has gone from looking to take care of his insides from substances to programs and spirituality, which goes to you never can tell mentally and emotionally what's happening unless you do the programming and you see what's happening here. He has a plan in the community. He has embraced the field of electrician, while inside he has a plan on outside. He, for me, as you further explored, I don't know anybody that has that much family support there that he certainly does. And although it's not through OVS, we do have victim input in the letter from the victim's older brother that was contained within our package.
Yeah.
And that in itself is, you can feel that. You know, when somebody takes your loved one, your brother, and yet you're able to go through and find a way to get there with that. It's important to me. Yeah, one of the letters came from Mac Young, who was in similar circumstances, who received a commutation and is in the community doing incredibly well, helping people that have the same circumstances that Mr. Charles and he had. And the only way that you can really try to make up for that life that you took is to help not create more victims. And when you can do that and you can be there and support people who are young in making the right choices and in dealing with what they have going on inside because of experience, I think that all of those things rise to the level of exceptional and compelling.
Thank you, Mr. Pohl. I would agree with everything you said. It's very clear here that Mr. Charles has gone above and beyond in his endeavors while incarcerated to improve himself and be able to help others. I would also add that our Connecticut legislature has recognized that our youth is not necessarily fully culpable for their actions. He was 18 years old when he committed this crime, and we know that there are two public acts, one for lengthy sentences committed by youth under 18, and more recently, a public act for under 21. Of course, he's not eligible for that because of date technicalities when the crime was when he was convicted. But there is a recognition that, you know, young people make horrible decisions at times, and this is the result. But I agree, he has everything going for him. When he gets out, he has prepared himself. He has the necessary tools and the support to be successful and turn things around while he's still young enough to do so. Ms. Page?
I agree.
Okay. So we'd have to consider a time frame. He's been incarcerated for almost 20 years, so he's not yet even at half of his sentence. My thoughts are somewhere between 18 and 20 years. What are your thoughts?
In terms of 18 to 20 years of incarceration or
No, commute. Well, he's only been a reduction. Yeah.
So for me, you know, part of what we're looking at here is there is, you know, society is owed a debt because there's a life taken.
Right.
The minimum requirement on a murder conviction is 25 years, which would, based upon what I'm looking at here, would have Mr. Charles still incarcerated for another 5 years. So if that's the case, I don't know how much further incarceration after that would accomplish. I think that he's done incredible things. I think he's set himself up and set himself up doing the right things.
Mm-hmm.
I would support it. I would support bringing the sentence, considering as well the juvenile reconsideration, the fact that this crime was committed at age 18. I would be supportive of reducing the 48 years to 25 years.
So 23, that's almost half. And we remember that in the juvenile reconsideration case, they have to do at least 60%. What are your thoughts, Ms. Page?
Madam Chair, I was thinking along the same lines as you. I did take into consideration some of the things that Mr. Pohl said. I Googled, you know, what's an average sentence for murder convictions or manslaughter. I saw between 25 and 60 years. And so in comparison to what he was sentenced to 48 years, they offered him 30. So I was thinking 18 to 22, somewhere in the middle. 18 to 20 as well, instead of as two. So that's where I am. So I don't even know what the percentage would be with the 18 to 20 years, but I just thought that number was in the middle. And I thought that would be fair based on his behavior there in the facility and all the strides that he's made to turn his life around. So
Want to settle on 19 years?
So that would
19 years. Instead of 29 year sentence.
that would have him being incarcerated until 2033.
Right, when right now it's 2052. Okay,
I would support 20 if we can get there.
I
60% is 29 years.
okay. Yeah,
Is that
It is.
okay?
okay. I'm fine with that. Thank you, Madam Chair.
And yeah, we actually failed to mention that there was an offer, yeah. Okay.
No, he did. He mentioned it.
Oh, we did, okay, yes. Okay. Very good. In the matter of Jared Charles, inmate number 325078, I'll make a motion to commute the murder sentence from 48 years to 29 years. Okay. So we're commuting 19 years from the 48-year sentence. Due to the exceptional and compelling circumstances that we found here in his presentation and in his record over the past 20 years while incarcerated. Is there a second to the motion? Sir, do you have questions? Attorney Moreau, do you have questions?
I do not. Thank you all.
Okay. Continue on your positive path while you're there, sir, and we certainly wish you the best.
Thank you, ma'am. Thank you to the board as well.
This now concludes the March 13th, 2024 commutation session of the Connecticut Board of Pardons and Paroles for inmate Jared Charles, inmate number 325078. Thank you, sir.
Thank you.